Can you hear me?
Yes.
Okay, I'm going to can you see my desktop?
Not yet. I see a final draft. Ed Branch, there you go. Now I see your desktop.
Okay.
Hang up your phone.
Ask them if they have any questions about last week's the
They
letters.
hear you. They hear what you're saying. We have one question on the board so far. Welcome, everybody, to AIB Radio's County Assemblies, Jean Blaine and Maria Janet, this 7th day of May 2011. Question, Jean, is, when we fill out the 8281, what kind of response should we expect from the bank or entity? We're still 5 minutes ahead, Jean, on our broadcast. We're open up for 5 minutes early here. Go ahead and answer the question. We'll take a few more questions before we get started.
The purpose of 8281 is to establish yourself as the issuer of the security or the original issue discount. That's spelled out in Title 15, Section 77, CA8. Defines what an issuer is. You're the issuer, and the 8281 is how you identify yourself as one. That's why you have to file the 8281.
Okay.
But there's, see, they never transferred any of these. I've got a case that I'm involved in right now in bankruptcy court.
Okay.
And I wrote up a declaration in an affidavit form with all these issues into the declaration.
And what did they say?
Well, we haven't filed it yet. This judge is the judge is very hostile towards Ed because of he filed a bunch of James McBride.
Yeah.
He filed a bunch of James McBride stuff, and which is frivolous. And the judge was on his side, but now he's kind of hostile.
Yeah.
I want to file an adversary complaint. I've been working on that all day, but we're trying to he gave us a 2-week extension. Well, I asked for 30 days, and the judge wants him to have an attorney. And see, they went into a Chapter 12 because it's farm property. But one of he has 3 properties, and one of the properties is a residence. The main property of the loan is a residential loan. The other one is lies together. They're all lumped together. One of them goes into default. They're all in default.
Okay. So, talk a little bit about the trustee relationships and what's going on.
What I found out is I called the U.S. Trustee's office, and I found out that all these trustees are bonded. And this one is being a real bitch. She's taking all of Ed's money. He makes money because he's a farmer. He grows crops, and he makes, $100,000. They confiscated. She's gotten confiscated $300,000 and she's not giving him any of the money. She's just sitting there holding all this money.
Yeah.
As part of this chapter 12, see?
Okay.
This is Bank of America. And the comptroller of currency has issued a cease and desist order to Bank of America on all residential loans.
Right. We got the emails on that. Okay. We have a question.
They also have a committee. You guys need to read the letter. In there, they have a foreclosure judicial committee. And they have to show that they're the owner of the note, and they can't do that.
Okay. So we have a question here, Jean, about the template you said you're going to have 2 weeks ago. Is that ready?
Template for what?
Was the mortgage letter rogatory.
Well, that's not done yet.
It's not ready yet. Okay, so we don't have the template ready yet.
It'll be ready next week.
Okay. Question 3. I contacted my state treasurer for a QSIP number for my court case and got this reply. A QSIP refers to the identifying number for a specific stock issue. I don't see the connection with a court case. Please explain.
The connection is he's the chief financial officer of the state treasurer's office has got a deposit agreement with the Federal Reserve Bank. A deposit agreement, a security agreement, and a escrow agreement under, tell them to go read circular, it depends on which state you're in. In North Carolina, they use circular 16. I've tried to get a copy of circular 16, but I haven't been successful yet. But
okay,
circular 7 can be downloaded off the web.
Okay.
In California, they use circular 7.
All right. But you can also put that in discovery and make it a discovery question if you have a case going. Like some of these people in the bankruptcy court, they've had adversary complaints going, and the judges come along and dismiss them all. So how do you stop a judge from dismissing your way other than going and filing an ordinary suit in district court, you know, in the federal court against the trustee and the judge and the bankruptcy people and the mortgage company CEO? And then go into discovery.
Well, what are you arguing in the adversary complaint?
Well, it's a foreclosure case.
Yeah, but you guys need to, this may be a good time to go into that. If you want to go into it, I'll go into it. I have a copy of what there's certain things that have to be in an adversary complaint. And let me see if I can find there's a form. They have a form, and it tells you what has to be in the form.
In the adversary,
Yeah, this is online. This is I found this form online, and it's really good.
I don't think we're even aware of a form. Is that the adversary form?
Yeah, it's for an adversary.
Yeah, it's a cover sheet. It's a cover sheet.
No, it's not a cover sheet. This is not. You're talking about the 104 form. 104.
Bring that up. If you've got that, bring that up. And I don't think anybody's aware of that.
Oh, I know they're not.
And that's why the adversary complaints keep getting dismissed.
Thrown out. You're not doing it right.
Okay.
I'm going to do one this week. In fact, I was working on it all day today, but I haven't got it finished.
we've got a lot of people that are being put out on the street and bleeding, and they're Bank of America and they're all the other banks that the comptroller put out a cease and desist on.
Okay, let's see. Where is this? Title 11. I had it here.
Yeah, we all thought that an adversary complaint was much like a criminal complaint in the regular court.
Okay, this is what a, can you see this?
Yeah?
This is what an adversary complaint looks like. This is the form for it. We're doing one.
Right.
What you need to do is read these rules. And we're going to go into there. We're going to go in there and read these rules so you can see. But this is the form. Is under section. This is a bankruptcy preference under section 547. And what this is, when you get around all the semantics, it's a set-off. That's your recoupment and set-off.
Okay.
And I'll show you. There's a bunch of I got a bunch of cases. You see what this says? Can you read? Go ahead and read this.
Complaint to avoid and recover. Preferential transfers. Plaintiff, customer's bankruptcy's representative, plan administrator of bankrupt customer. The plan administrator brings the instant complaint to avoid and recover preferential transfers made by bankrupt customer, the debtor, to defendant, your company, the defendant, prior to the filing of the debtor's respective petitions for relief under Chapter 11 of the United States Bankruptcy Code, 11 U.S.C. subsection 101 et sec, the Bankruptcy Code.
Okay, this is you have to have a jurisdiction and venue statement in there.
Okay.
Go ahead and read that.
This is an adversary proceeding pursuant to Rule 7001 of the Federal Rules of Bankruptcy Procedure and Section 547B of the Bankruptcy Code to recover avoidable transfers made by the debtor to the defendant. This court has jurisdiction over this proceeding pursuant to 28 U.S.C. 1334. This adversary proceeding constitutes a core proceeding pursuant to 28 U.S.C. Section 157B2F, big F, small b. This district is the proper venue for this proceeding pursuant to 28 U.S.C. Section 1409.
Then you have to put, read this.
Which one?
Parties.
Burbagged Wendell annotation. In multiple debtor bankruptcies, we cannot emphasize enough the importance of making sure that you advise your counsel if you contracted with or provided goods or services to more than one of the named debtors. The preference creditor collector may try and lump all the debtors together in making a preference claim. This may allow the preference creditor to avoid defenses and may damage your ability to prove defenses. Incorrect debtor identification or failing to distinguish between debtors may not occur often, but when it does, it can be a big obstacle in bankruptcy preference defense. Explain some of that.
Okay, what does this say? Remember I told you about 111.203? Do you remember that?
Probably. It's in one that's on one of the webinars.
Okay, let me show you what it says.
Go ahead, Gina. I got to take this call. Who is this? Okay. I'll try and go get it. We should cut it off at 5:30.
Okay, you back?
Are you there, Jane?
Yeah, I'm here.
Okay. I got one person
Okay.
to approve. I'll be right back to read. Okay, I'm back. Where do you want me to read?
Okay, what does that say? This is page
1418,
1413.
defense to foreclosure. Section
Okay,
130.
remember in the adversarial complaint, the form, it talked about a defense?
Yes.
Well, this is the defense they're talking about. This is what
Okay.
you have to use in the complaint. Otherwise, you don't state a claim upon which the court can grant relief.
And that's why they keep dismissing it.
Right.
Okay, so that's why we have to have in our adversary complaints this 1413 defense to foreclosure.
Read this. Go
Section
ahead, read it.
130 of the Truth in Lending Act, 15 U.S.C. 1640, is amended by adding at the end of the following new section, K, defense to foreclosure. Number 1, in general, notwithstanding any of the provision of law, when a creditor, assignee, or other holder of a residential, pull it down, mortgage, loan, or anyone acting on behalf of such creditor, assignee, or holder initiates a judicial or non-judicial foreclosure of the residential mortgage loan or with any other action to collect the debt in connection with such loan, a consumer may assert a violation by a creditor of paragraph 1 or 2 of section 129B, small c, or of section 129C, small a, as a matter of defense by recoupment or set-off without regard for the time limit on a private action for damages under subsection E. Number 2, amount of recoupment or set-off. A, in general, the amount of recoupment or set-off under paragraph 1 shall equal the amount to which the consumer would be entitled under subsection A for damages for a valid claim brought in an original action against the creditor, plus the cost to the consumer of the action, including a reasonable attorney's fee. B, special rule. Where such judgment is rendered after the expiration of the applicable time limit on a private action for damages under subsection E, the amount of recoupment or set-off under paragraph 1 derived from damages under subsection A4 shall not exceed the amount to which the consumer would have been entitled under section A4 for damages computed up to the day preceding the expiration of the applicable time limit.
Okay, that's the defense that they're talking about.
Okay, explain that a little bit.
Okay, you have you got to use this in conjunction with recoupment comes under 3-305. Okay.
Everybody qualifies for recoupment, don't they?
Yeah, I'm going to show you. Now, remember, okay, has everybody got this? Does everybody have a copy of this law?
Well, they're going to have it on a screenshot now.
You can download this. This is Public Law 111-203, July 21st, 2010. But
Okay.
what they're referring to here, under the Uniform Commercial Code, I'm going to go in there to the Uniform Commercial Code, show you.
Somebody wants to know about the comptroller and the Bank of America, the cease and desist. They're saying, how can we find out about that?
I've got copies of it.
I do
all
too.
the stuff.
I do too on my email.
And we'll post it for everybody.
Okay.
So you read it. You need to read Article 7.
Okay. Circular 16 was integrated into Appendix A of Circular 7.
Here's your defenses. 3-305. What does that say?
So I get to it. Defenses and claims and recoupment. We've read that several times. We have a screenshot here. We've gone over the holder in due course. We've gone on to over 3-306. They can't prove that they're holder in due course. So on their part, defense would be number 1. Fraud, vitiates everything, and that's in number 3, A3, small III. If fraud is used to induce anything, then it invalidates the entire contract.
Yeah.
And so there's one of the simplest things you can say. There was fraud in the fact that they chose themselves to be beneficiaries when I'm the true beneficiary. They can't be holder. They can't prove that I'm the decedent. So how can they hold me liable if I've never taken liability for that decedent? I'm the beneficiary of the decedent's estate.
And also, if you read this, it says, an obligor is not obliged to pay the instrument if the person seeking enforcement of the instrument does not have rights of a holder in due course.
Right, and they can't have rights of a holder in due course. There's no possible way they can have rights of a holder in due course because they're not. Can never be the holder in due course.
Yeah, because they took it subject to your defenses and claims. So they can't be a holder in due course.
Right.
But a holder in due course under 3-302 takes it free of all defenses and claims. That's why you have to use this.
Okay.
And also you can use 3-306. Read that right here, 3-3.
Claims to an instrument. A person taking an instrument other than a person having rights of a holder in due course is subject to a claim of a property or possessory right in the instrument or its proceeds, including a claim to rescind a negotiation and to recover the instrument or its proceeds. A person having rights of a holder in due course takes free of the claim of the instrument.
So you have a possessionary right, and the reason you have a possessionary right is because this goes to, and this goes back to 4-102.
Okay, so what should a person do that's been trying to get into the adversary court and they keep dismissing it?
Well, you need to write this down. Applicability. Read this. What does that say?
To the extent that items written within this article are also within Articles 3 and 6, 3 and 8, they are subject to those articles. If there is conflict, this article governs Article 3, but Article 6, that's 8. Article 8 governs this article.
Okay, why does Article 8 govern 3?
I don't know.
Well, what is Article 8? Under the pooling and servicing agreement, what are you dealing with?
A security.
Okay. And what are they? Mortgage-backed securities, aren't they?
Yes.
Okay, so if you have a security involved, then you have an adverse claim. And what does it say? What does that say? Read that. Adverse claim.
Under adverse claim means a claim that a claimant has a property interest in a financial asset and that it is a violation of the rights of the claimant for another person to hold, transfer, or deal with the financial asset.
Doesn't that explain why they don't transfer it to the REMIC?
Yeah, because it's a violation of the rights.
Okay, so if you have an adverse claim, then you're an entitlement holder. What does that say?
Okay, entitlement holder is a person identified in the records of a securities intermediary as a person having a security entitlement against the securities intermediary. If a person acquires a security entitlement by virtue of Section 8501B1, B2, or 3, that person is the entitlement holder.
Okay, so what does 8-5051 say?
You got to go up a little bit.
8-501. What does it say?
Securities account acquisition of security entitlement from securities intermediary. Okay.
What is B? Read B1 and 2. 1, 2, and 3.
Except as otherwise provided in subsections D and E, a person acquires a security entitlement of a securities intermediary. One.
If. It doesn't say it says if.
Oh, if a securities intermediary, 1, indicates by book entry that a financial asset has been credited to the person's securities account, or 2, receives a financial asset from the person or acquires a financial asset for the person, and in either case accepts it for credit to the person's security account, or 3, becomes obligated under other law, regulation, or rule to credit a financial asset to the person's security account. Isn't that what they did, was credited?
Yeah.
So they were obligated to credit it. It belongs to the people.
Yeah.
Okay, question number 3. Guaranty Trust Company versus Henwood is one case which Supreme Court says the banks must allow the people to set off their debt. You said last week that this case was part of the case law. Please cite the other cases involved.
Give me the name of the case. You got the site on it?
No, they just typed Guaranty Trust Company versus Henwood.
That's HAR 192.
Okay. Can you do an adversary complaint in an affidavit form?
You said Guarantee, what was the name of it? Henwood
Trust
versus
Company
Guarantee Trust Company?
versus Henwood.
No, you have to do it in the, see, I'm going over this. This is what you need to be, this is what you need to put into your complaint. I'm going to do one this week. I'll have it done this week, and we can go over it next week.
Okay, I'll put that down on our list to go over next week.
But this shows, this is what you have to, that has to go in here. But you have to have a statement. The complaint has to be in proper form. You're not putting it in proper form.
So an affidavit won't work?
No, that's not proper form. This is not an affidavit.
Okay. So that's where we go back to this first screenshot that you were showing us, what needed to be in an adversary complaint.
I'm going to give this out. This is, you put your, see where it says parties?
Yeah.
Here's your, up here is your jurisdiction and venue statement. These are the sections that give the court jurisdiction.
Where? Jurisdiction and venue.
It's section 547B. You need to read these sections.
Okay.
This is where that preference comes from.
Okay.
Voidable transfer. Well, they transferred the note, didn't they?
Yeah.
Okay, so that's a voidable transfer, isn't it? Because they could not transfer it because of your adverse claim. Remember, you're a third-party beneficiary to the pooling and servicing agreement. That's what that Horace versus LaSalle National Bank down in Alabama was decided March of 2011.
Okay.
One month ago. He said that the borrower was a third-party beneficiary. These are the, you put down here your parties, who your parties are. This may allow the preference collector to avoid defenses and may damage your ability to prove defenses. Now, the defenses they were talking about are in 3-305, recoupment and set-off.
Okay.
But you have to understand what your defense is.
Well, the defense is that they never transferred into the REMIC, and they brought fraud into the equation. Fraud vitiates everything, and they didn't pay the taxes on the REMIC. And we have set-off and recoupment under this 547B.
It may damage your ability to prove defenses. Incorrect debtor identification or failing to distinguish between debtors may not occur often, but when it does, it can be a big obstacle in bankruptcy preference defense.
Explain that.
Well, this is if you have multiple claims. This case that I'm involved in, they have multiple claims in there because this is a farm property.
Okay.
Bank of America doesn't have standing to bring a claim because they're not the holder in due course. Remember what it said under 3?
Well, yeah, to be a holder, you take it without defenses, not being subject to any defenses. You're not a holder unless, if there's defenses, then you can't be a holder.
That's right.
Yeah. Okay, we have somebody here that wrote a pretty long question. I'll go back and read it. On the conditional acceptance, a local IRS agent is demanding we show up for an audit as non-filers. We sent 2 registered letters to the agent with a conditional acceptance signed in red ink. He answered by certified return mail that Congress gave him the authority and he doesn't have to answer us. He states he expects us in his office on Wednesday, signed his name in red. We sent each set certified letter, another conditional acceptance signed in red. Any suggestions as now how to get rid of this agent? We have 4 red labels from his envelopes.
Have you filed tax returns? What is it he wants? Did he send you a tax bill?
They want to do an audit.
Have they been filing tax returns?
They're not saying. I'll see if it goes further down on the questions. They're saying they signed as Grantler, Settler, Executor, Authorized Representative. There's a Supreme Court case stating that no one is bound to attend an audit from an IRS agent.
We can't get on.
Do you recall that one? It says that no one is bound to attend an audit from an IRS agent. Do you recall that one?
Yeah, I recall it, but I don't know what the name of the case is.
Okay. Boy, these questions are all over the place tonight. I think I'm just going to leave the questions go a minute and just pull it back in and get on track here.
See, you have a preferential transfer. That's when you transferred the note to Bank of America, the security.
That's a preferential?
Yes.
Excuse me. So we had the preferential transfer.
You made a preferential transfer of a security to Bank of America.
Right. So when we did that, they can't claim a claim against us because we have the right of offset and set off.
Right.
So that's what you're, when you go into the adversary hearing with this form here, that's what you're telling the judge.
Well, you have a right to avoid the transfer.
Explain that.
Well, because they took they made proceeds off of the transfer.
And those proceeds need to come back to us.
It needs to come back to you as a recoupment or set-off.
Right.
Because you made an adverse claim.
And the adverse claim is the adversarial complaint?
Well, no, but the adverse claim is your claim. You have a right to the proceeds, a possessory right in the instrument and its proceeds under 3-306. Remember, 8 controls 3 when it's includable in 3.
Okay.
And it's includable in 3 because it's a security.
But how does that stop the judge from letting the bank walk all over?
With securities, not negotiable instruments.
So when we keep talking to the court, we need to be identifying it as a security, not a negotiable instrument.
Right. You quit talking about a note.
Okay.
You should be talking about a security under Title 15.
Okay.
Inclusio es exclusio alteris. That's a rule of statutory construction. If a instrument is included in the definition of a security, it's excluded from the definition of a note. And conversely, if it's included in the definition of a note, it's excluded from the definition of a security. In other words, it can't be both a note and security.
It's got to be one or the other.
It's got to be one or the other.
Okay.
Payments by the debtors. Okay, so you made a payment, didn't you? And where does it say that? Doesn't it say that in FASB number 95, Statement of Cash Flows?
Yeah.
In the manner and amount set forth in Exhibit 1, attached hereto. Payments by the debtors.
Okay.
They endorsed the security for payment. Pay to the order of.
Okay.
So what does that do? It says count 1. Now here's how you state your claims.
Okay. The
See,
following
if you
causes
compare
of
the
action.
allegation, if you compare the allegations in count 1 with the facts that the trustee is required to prove, you will see that the paragraphs below practically are word for word taken from section 547B.
Okay.
So we're gonna click on here 547B.
Over to the right a little bit, it should click on section. Go to the, there you go. Well, we read that up above, didn't we?
Okay, here's preferences. Section 547. Remember it said B?
Yeah.
Okay, here's B.
Except as provided in subsection C and I of this section, the trustee may avoid any transfer of an interest of the debtor in property to or for the benefit of a creditor.
So you transferred the note to at closing.
Yeah.
So the trustee may void the entire
Transfer.
Yeah, the transfer
The
which
entire
was made.
loan.
Yeah, so to what? To and for the benefit of a creditor.
Okay, that's not a holder. Right?
Yeah, so and it says that makes it when you endorsed it and before it was transferred, you had an antecedent debt owed by the debtor before just transfer was made.
Explain that a little bit.
Well, antecedent means...
What is an antecedent debt?
That means that it's a debt, it's defined in, let me find the definition here. Here's the definition that the court, you want to use these definitions. Okay, read this. This tells you what it is.
The phrase antecedent debt is not defined in bankruptcy code. To understand the phrase requires something of its words to be understood separately. Just a minute, my control panel's in the way. It requires that each of its words be understood separately.
Go ahead.
Under the code, a debt is a liability on a claim. Section 101(12). A claim, in turn, is a right to payment, whether or not such right is reduced to judgment, liquidated, unliquidated, fixed, contingent, matured, unmatured, disputed, undisputed, legal, equitable, secured, or unsecured. Section 101(5). Simply, a debt is any obligation of the debtor. The term antecedent means comes before. So antecedent debt means an obligation that comes before a transfer. The plainest example is when you receive a payment against what you already are owed at the time of the payment.
So at the time they deposited, you made a payment to the bank.
And that was the gift, that was the note.
That was the donation. Under 3-105, you were the issuer. What does 3-105 say?
Well, we're the maker. It's our signature that authored the payment.
Yeah, but you made the first payment transfer as the issue, and you were which was the drawer and the maker.
Right.
So you made a payment to an antecedent payment to the bank.
Before the transfer.
Yeah.
So then the bank is liable to us, not us liable to them.
Well, you have a right to recoupment or set off
Of that payment.
of that payment. You see how reading this clicking on this, and see it tells you in here, defines you, it explains what's going on. That's why you guys you're not making a claim or a defense in recoupment.
And that's what has to be done in an adversary complaint.
Right. Isn't that what it says? This came off a bankruptcy website.
Yeah.
A bankruptcy court, all 93 of these bankruptcy courts operate under the same rules.
Okay.
Now this also says that you have, this section here says that you have a right. What does that say? Can you read that?
Which one? Set off?
Yeah, this is section 553. Read what it says.
How except as otherwise provided in this section and in sections 362 and 363 of this title does not affect any right of a creditor to offset a mutual debt owing by such creditor to the debtor that arose before the complaint against the debtor that arose before the commencement of the case, except to the extent that the claim of such creditor against the debtor is disallowed. Such claim was transferred by an entity other than the debtor to such creditor after commencement of the case. Okay, so when we do...
So this came before the petition was filed, didn't it?
The right to set off, yeah, and the defense was long before the petition was filed.
So it's an antecedent debt, isn't it?
Now, does the bank have any defense to that?
We can't get around it.
So these are the type of things that you put in adversary hearings and into a request for admissions and a request for productions in discovery.
Yeah, you can put in there under the Patriot Act, you need to write this down, Title 31, Section 5311.
And what is that?
That's the Patriot Act, the Bank Secrecy Act.
We went over that last week.
Okay, you need to start writing this stuff down. And the Treasury regulation that governs the Bank Secrecy Act is Treasury Regulation 103.11. And what it says is that they have to file currency money instrument reports, CMIRs, transportation reports. To show the source of the money. This is how you prove your case.
Okay, so when you send the trustee the notice of the current comptroller of the currency report and that law that said Bank of America was to cease and desist, and Bank of America still scheduled the sale. What do you do then?
I would contact the comptroller of currency.
That's where we really need to be making, when these adversary complaints are dismissed, we need to be sending notice to the comptroller of the currency under a complaint to them under all of these violations that they're doing. Because we're finding that the bank does not answer you. The trustees don't answer you. Are the people non-filers when they don't receive a bill from IRS? There's one here. Can we use the JAG to put the judge and prosecutor in order in the IRS cause because we are the beneficiaries? The JAG
Here's a video that tells you how to put an adversarial complaint together. Do you want me to run this? This is a law firm.
Yeah. Is it very long?
No.
Okay. Let's put it on here so people can see.
I downloaded this off of the web. It tells you how to put a petition together. Can you hear it all right?
We're not hearing anything. Has it started?
Yeah.
No, we're not hearing anything.
I can hear it.
Well, it's because you've got your headset on.
Well, you can
just let it go through and we'll get the screenshots and maybe someone will be able to go in on that link on the first screenshot. Sometimes just reading what's on the paper will help. While that's going through that, we have a question here. The 8281. The 8281 is not a note. So why do you think it's the note?
Why do I think what?
No, this person that wrote this question says the 8281 is a note, right? No, it's not.
It's a form.
It's a form.
Tax form.
For 8281. It's not a note. They're all securities. You're not listening, listener here, that a security is anything over 9 months old. So whether it's conveyed into the trust or not doesn't make any difference. Someone here says that they.
So you're trying to recover.
Go ahead.
You're recovering money and property. That's under number 1.
Yeah. Okay. Someone here says they sent a complaint to the Office of the Comptroller of the Currency and now has a file number from the OCC. The JAG's not going to help you with any kind, even though they are supposed to be commissioned and set up from Lincoln. They're going to always use the excuse that they can't come off the military property. So the comptroller is probably not going to help anything, is it, Gene? I mean the JAG, Judge Advocate Council, something like that.
You should file it with the comptroller of currency.
I think that's where you get more. You'll get the squeak is much bigger with the comptroller of the currency. Now, what if you're dealing with property taxes or a criminal case in the court? Should you still go through the comptroller of the currency?
No.
Okay.
Can you see my screen?
Yep, everybody's watching it.
You should watch this video and take notes. There's the caption. This is how you caption your complaint.
Right. Now we had someone here, comptroller from Texas, sent a form letter in response to a complaint. We have go to webinar will not broadcast video volume. Oh, that's why you don't hear the video. But the link is on there so we can go copy it off or download it another day.
See, these are the elements, what you have to say.
Okay, our caller here is saying that the 8281 form is to file for a note.
No, it's
I
not.
don't think so. Can adversary also be done in Chapter 7? Oh,
Yes.
it says here that this Burba Weddle is available by Google. If you just Google Burba Weddle, you'll get that, what you're showing on the screen.
I got this off a bankruptcy website.
Adversary is usually tailored for bankruptcy court. Is a redemption manual 4.5 good? Still good to use?
Yes.
That's the end of our questions for the moment.
Okay, we're going to go back to, but that shows you how to, this shows you how to put a bankruptcy complaint together.
Good. Okay, that's good. So I think we can go in and find this one and Google it and pull it down and get the volume to it when we watch it. But the format of what they did was very good.
But it shows you how to put it together properly. Okay, now we're back to this is the form. This shows you how to lay it out. If you didn't get all that from the video, then you can use this. This is an actual complaint.
Right. So if we just go through this publication also, we'll learn what to do. So if you recently had an adversary complaint dismissed, could you not go back in on a reconsideration if the time has not run?
Yeah, you want leave to amend the complaint.
Well, they've already dismissed the complaint.
Why did they dismiss the complaint?
They're saying that you didn't make a claim upon which relief can be granted. And now I see why.
This is why you got to do, guys, don't do things right. People think that all they have to do is put words down there on a piece of paper, and they See, under 502D, you can disallow claims pursuant to 11 USC 502D.
Is that also in a 13 when you're in the Chapter 13 bankruptcy?
Yeah, you can do this in any chapter.
Okay. So what a person ought to do is when they file bankruptcy, they need to go directly into adversary.
Right.
At the same time.
And you need to file a B10 form.
Why would the debtor do a B10 form? Under this 502D?
Well, let me show you. You guys got to start reading stuff. That's why you're not getting a remedy.
I didn't think the debtor in a bankruptcy could file a proof of claim.
Yeah, you can.
So where you've got on the form there, Bank of America, would you put your name?
It says nature of property or right of set-off, doesn't it?
Yeah.
Does that say right of recoupment or set-off as defense to foreclosure? 15 USC 1640?
Okay. But up above you have Bank of America. Why would you have Bank of America in the debtor position?
Well, because they're the ones that owe the claim. You become the plaintiff and they become the defendant in an adverse.
In an adversary complaint, they become the defendant and you become the plaintiff. You become the creditor and they become the debtor.
How can you win anything at bankruptcy court unless you're a creditor?
Well, that's true.
Well, you're not establishing that you're a claim upon which the court can grant relief.
So this B210 would be just in the adversary here complaint part of the bankruptcy,
Right?
Not in the regular bankruptcy.
And you gotta file this with it. I'm going to have one all done next week.
Okay.
It says nature of property, secured claim, nature of property or right of set-off.
Yeah.
Then you got to do the cover sheet. I'll have all this done next week.
Okay, so
okay. Here's the cover sheet. Here's the cover sheet you got to do.
You're going to have this ready so our listeners can have it before next Saturday?
Yeah.
Okay.
This is the cover sheet you got to use. You got to put in a cover sheet.
Right. I think all of us have been involved with adversary hearings understand the cover sheet.
See, this is you got to put down, here's 7001. Remember, it said 7001? I think 7003 was in here too. but you're recovering money and property. You have a possessionary right and a possessionary and property right in the instrument or its proceeds.
Okay.
Why do you have it? Because you made the first payment order. See, this goes back to the Uniform Commercial Code. It goes back to 3-105 of the Uniform Commercial Code. You need to write these sections down. What does that say? Issue.
Issue means the first delivery of an instrument containing an acknowledgement by a bank that a sum of money has been received by the bank and a promise by the bank to repay the sum of money.
Where are you reading?
Oh, that's a certificate of deposit. I was reading the wrong thing. Issue of instrument. Issue means the first delivery of an instrument by the maker or drawer, whether to a holder, non-holder, for the purpose of giving rights on the instrument to any person. Issuer applies to issued and unissued instruments and means a maker or drawer of an instrument.
Well, weren't you the maker of the drawer?
Well, yeah, because we authored it. It's our signature that brought it to life.
Okay, what is this? Read this. E.
E. An instrument is a note if it is a promise and is a draft if it is an order. If an instrument falls within the definition of both note and draft, a person entitled to enforce the instrument may treat it as either. Explain them.
Well, when they get a note is a liability instrument because it's a promise to pay money. If they endorse the note on the front or the back, pay to the order of, that's now an order to pay or a draft. It's no longer a liability instrument.
Okay.
So that's what that's saying. It's a draft. If it falls within the definition of both note and draft, person entitled to enforce the instrument may treat it as either. Well, they treated it as a draft because they endorsed it for payment.
Okay.
That's what they used to pay the seller.
Right.
They're debtors in possession under a Chapter 11 reorganization, acting as debtors to the bank, acting as trustees to the bankrupt estate.
And that's why they have to give it back to you.
That's right. You delivered. You were means the first delivery of an instrument by the drawer and the maker. Now you go over here to
We're all learning the why and the what for. But how do you stop the judges that absolutely will not be stopped?
Get in their pocketbook.
Well, and that's about the only answer that we have is to turn around and file a private suit against them.
File an adverse claim with the court.
Yeah. So, but don't you have to have an active case to put that into?
Well, we were talking about having a case. If you got a judge, if you're in front of a judge, you've got a case. Go ask them for the deposit agreement and the security agreement and the escrow agreement.
I still have that outstanding on my discovery. Nobody's answered anything.
I wonder why.
We know they can't really answer it. But they keep moving their cases ahead regardless.
Put a lien on them. Do a UCC1.
Well, we have some people that did that, and now they're looking at 30 years in prison. How do you get rid of that to go back to square one and correct any mistakes that you did?
Well, you're saying somebody did that. You show me somebody that did it right and is looking at...
I didn't say it was right. I said now they're looking at 30 years of prison because
for what?
they came in and charged them with filing false instruments. They did have some errors.
Well, I haven't seen the paperwork, so I can't tell you what they did wrong. Send me the paperwork, and I'll tell you what you did wrong.
Send you a copy of their lien?
Yeah.
Okay, and then how would you go back and correct it?
Do it right.
Turn around and resubmit it in the correct form?
Put the lien. You know who underwrites these court judgments? PIMCO bonds.
Yeah.
Well, they're the underwriter. That's who you need to go after.
Okay. But how good is that going to help the person that's been incarcerated?
Well, you're responsible for what you do. This is why you got to do things right. Instead of listening to all these people that are telling people to go out there and put lien judges and do all that stuff. It's not the judge that's the problem. It's the people. They're not doing things right.
Well, that's true. We don't have very good instruction booklets, and we don't know where to go look.
Okay, what does this say? Read this. Originator.
Means the sender of the first payment order in a funds transfer.
Okay, what is a payment order?
Well, that's like the money order, pay to the order of, isn't it?
Yeah, means an instruction of a sender to a receiving bank transmitted orally or in writing to pay or cause another bank to pay a fixed or terminal amount of money to a beneficiary. You got all of your documentation right here.
So what you have to do is just go in and file a separate suit against everybody.
Well, you don't need to file a suit. What you need to do is put a lien. You need to, go find out where PIMCO Bonds is located.
You said that on about the webinar on probably 319. I remember you talking about it.
Okay, Euler Hermes is the underwriter, and that's a subdivision of Allianz SE out of Munich, Germany. This is, you guys want to get into their pocketbook. I want to show you something. This is the insurance company.
Allianz.
What does that say?
One of the world's biggest
Read that.
insurers. Allianz SE offers a range of insurance products and services, including life, health, and property casualty coverage for individuals and businesses, through some 100 subsidiaries and affiliates operating all over the globe. Though its key markets are France, Germany, Italy, and the U.S. In addition to selling insurance, Allianz provides retail and institutional asset management services through Allianz Global Investors, private equity investment through Allianz Capital Partners, and banking services through Allianz Bank. Allianz operates as a Societies Europea, a joint stock company that is ruled by European Union standards.
This is and PIMCO Bonds is a
subsidiary.
Huh?
Is a subsidiary?
Yeah, PIMCO Bonds is a subdivision of this. This is their website here.
Okay. PIMCO, P-I-M-C-O.
This company is the U.S. arm of Allianz SE. they've changed their website around, but if you go in here, it talks about
So PIMCO bonds and funds are the ones that underwrite everything in the world?
they underwrite down in Bradstreet.
Okay. What's that got to do with the individual homeowner?
Well, that's who underwrites. All these courts have a DUNS number. Trying to find the section on bonds.
Well, that's going to take quite a bit of time. Why don't you bring that back next week? Let's move on to some people want to know about the how you bring this back, and really is the adversary complaint one of the only ways to
When you're in bankruptcy court, it is.
Right, but what if you're not in bankruptcy court, or maybe they have made a ruling that you can't file for 120 days? If you've tried to refile bankruptcy in adversary hearings 2 or 3 times. You can't go back into that. You have to go right back into a regular, ordinary federal court case.
Well, the only advantage of being in bankruptcy court is that you have an automatic stay when you go into bankruptcy.
These judges are lifting these stays left and right.
In bankruptcy court?
Yes. And they're dismissing the bankruptcies. They're dismissing the adversary complaints.
That's because they're not doing them right.
We recognize that, Gene. Now with what you've shown us tonight, that can be done. But what about the poor homeowner that's burnt the bridge 3 times over now, and there's nothing to build the bridge with again? Is there anything else that can be done to stop an eviction, to stop a sale?
Well, you can file an action in federal court or state court.
Right, it would have all the same elements that you had in the bankruptcy and the adversary. You would still have all the same questions.
You can't do an adversarial complaint in federal district court. You can only do that in bankruptcy court.
Are you saying only recoupment is available in the bankruptcy court?
No. But recoupment and set-off are defenses. You can use defenses in any court. You don't have to. You can only do an adversary complaint in bankruptcy court. You can't do it in a district court.
Well, yeah, because that's a bankruptcy type filing. But what do you do if you don't have bankruptcy available to you? You can't get at the adversary hearing.
Well, then you have to do a complaint for set off and recoupment.
Would that be also a quiet title?
You could do that in a quiet title, yeah.
Because the questions really should not change. If the bank is not holder and you have a defense of a recoupment and set off, it shouldn't matter where you bring that defense up.
You can raise the defense and recoupment, but you have to know how to present the claim to the court.
That's where people run into trouble, because the bankruptcy court has their format. The U.S. federal court has their format. It's all the same issues.
When you do a pleading, you have to do a short, people write books. I've seen complaints that are 300, they do a treatise. They put 50 cases in there, they put law journals in there, they put all this. If you study pleading, the rules of pleading, it's a short and concise statement.
That statement would be, there was fraud in this situation. I'm entitled to set off in recoupment. The bank is not the holder. End of complaint.
Yeah, but you got to state the grounds why they're not the holder.
Well, yeah, you go through what we went through tonight earlier. They're not the holder because they took that loan, so to speak, subject to my defenses. And you find the code section, the bankruptcy section, the law, whatever section in the law that says that is what you put in your complaint, ABC.
I'm going to have one done this week, so we can go over it.
All right, people are really, really needing this direction.
But you got to, when you do these things, you got to do them right.
Well, Gene, a lot of people have not gone to law school to figure out whether the recipe is in cursive or Arabic or printing.
You got to have you got form books that show you this is what attorneys do. They use form books. And what they do is they use a form book to put the like that, what I showed you, that adversary proceeding.
Yeah.
Or adversary complaint. That's
okay.
a form that shows you how to put it together. You don't need to write a book. Every patriot writes 300-400 pages of nonsense. The judge never reads it. I read a complaint by a guy in Colorado. It was 300 pages long.
Well, I guess because a lot of people, like myself included, previous years, thought that if we didn't put it on paper and we didn't get it in front of the court, that they have this double evidence file and it never got on the record, and so the judge never made a decision with anything that the living person said. We all recognize that the living person cannot be seen by the judge or heard by the judge, so how do you get the crap before him? You go to use an attorney, they sell you down the river because they have to. You go in by yourself, they don't see you or hear you. You're kind of sunk either way you go.
Well, go over on the private side before you get into a complaint.
Well, that's what people have been attempting to do with the money order process, with the conditional acceptance process. I mean, what right does a judge have to have anybody removed from a courtroom that's doing a conditional acceptance?
Well, I wasn't there, so I don't know what took place.
A simple conditional acceptance, and the judge said stop, and the person did not. and they removed him from the courtroom. What authority did that judge have to stop someone from making a conditional acceptance statement? There is no authority. There is nothing.
Well, you need to go after his bond. You keep defeating yourself by I tell you what to do, and you say, but somebody did this and they got thrown in jail. That's because they're not doing it right.
A lot of people need some examples to lead them down the right path.
You need to challenge these, like I just did I'll show you a letter. Here, I just did a letter today. I sent this out today. This is an account I had with Sears. You're not going to believe this. This is 30 years ago.
Okay.
This is 30 years ago.
That's what people need, are these examples.
This is a letter that I wrote today. It went out today. This is a Prudential Financials up in Pennsylvania.
Okay. This letter is being written in response to your letter regarding an alleged account number belonging to Sears. I am conditionally accepting your offer to pay the attached bill under sections 3501 to 1 to 1, is it? I can't read it.
3.
Huh?
3-501 subsection 2 and 3.
2, 3. Under the California Commercial Code upon proof of the following claims and facts. Well, that's much like your infinity letter, isn't it?
Yes.
Okay.
But I'm showing you how to put it together. These things really work if you do them right.
Okay. They're going to ask me this week, our students are going to ask, can we get a copy of this?
Yeah. Notice what I said at the end of the letter.
Number 7. Let me put my screen down here. You are required.
Let me get down here.
So you went in and pulled Sears prospectus?
Yep.
Well, you see, people are not able to go in and work Edgar Archives anymore.
You're not doing it right. Let me,
Well, this is very much like the infinity letter.
this difference is that. What does that say? Read that right there.
What am I reading? Point.
Right here.
Right where? Okay. Failure to provide the above documents or documentation within 30 days of the receipt of this letter is an admission by NCO Financial Systems, Inc. and Sears that they have submitted and filed a bogus and fraudulent claim and are liable to Gene Keating under sections 813.2a and 813.2b 2ii of 2BII of $500,000 or 1% of the net worth of NCO Financial Systems and Sears by the fines imposed under Section 1692K of the FDCPA at 15 USCA. I'll explain that.
Okay, I'll show you.
So now I'm going to put down letter to Sears on my little list here. Why is it 1%?
Because that's what the code says. This is, you guys need to write this down. They amended the Fair Debt Collections to provide that any attorney who collects debts on behalf of a client shall be subject to the provisions of this act.
Okay.
Because they're private debt collectors, they're not acting as attorneys.
So if they're acting for any client that they have to try and collect any kind of a judgment, let's say like this, or even a child support judgment, or a maintenance judgment, or attorney's fee judgment, they're acting as debt collectors rather than an attorney.
Right. They just had a case here in California. They settled for $500,000.
What was that case?
Well, let's see if I've got it here. I probably have to wait till next week to get it. But I've got it on the jury awarded them $500,000. It's a credit card case.
Okay, because they violated this section.
Because they violated the Fair Debt Collection Practices Act.
Okay.
I think this is the case here. They were a Mexican family.
What's the name of the case here? Fresno County versus Shaw, Recorder of the City of Coahuila.
No, this isn't it. I've got it here. What does that say?
It doesn't. Any case of any action by an individual, such additional damages as a court may allow, but in the case of a class action, it doesn't say anything there. And there you go. Such amount as the court may allow for all other class members without regard to a minimum individual recovery not to exceed the lesser of $500,000 or 1% of the net worth of the debt collector. What is this case?
This is not a case. This is the Fair Debt Collection Practices Act.
Oh, so that wasn't a case. That wasn't the one that awarded the $500,000.
No, this is a California case. It's up in Northern California.
Do you have that case?
I can find it. If you want, I'll do a search on it.
All right, I'll put that down on my list. The California FDCPA case. And if you'll get
Let me
it
see if I can. Let me see if I can find it. I might be able to find it real quick. Here it is.
where?
Right here.
Okay, put it up on a screenshot so we can get a screenshot.
What does it say?
California couple awarded $500,000 in FDCPA case. But it doesn't say the name of the case.
Read it.
Last
That's
month,
true.
Manuel and Luz Fausto won one of the largest collection awards documented in the last couple of years under the Fair Debt Collection Practices Act against Credigy Services Corporation. A California jury awarded the Faustos $500,000 in damages caused from harassment by Credigy collectors. On the sum granted, $100,000 was for actual damages the Faustos experienced, while $400,000 was in punitive damages granted for malicious and reckless disregard of the couple's rights. According to one of the Faustos' lawyers, David Humphreys at Humphreys Wallace Humphreys PC, and the case stemmed from a debt on a Wells Fargo charge card opened in '92. Humphreys stated that Faustos consistently paid the account balance on the credit card, but the balance kept increasing. The Faustos then requested that the account be frozen, but their request was declined by Wells Fargo branch. Humphreys said Faustos received assistance in paying the balance from local businesses that promised to negotiate a discounted payoff of credit card balances. The Faustos were under the impression that the debt owed to Wells Fargo was paid off with two money orders in late 1990s. In 2006, Credigy contacted Faustos with a demand of almost $17,000. Humphreys noted that a Brazilian affiliate of Credigy made over 90 threatening calls and sent numerous letters to the Faustos' home even after cease and desist notice was sent to the company. Luz Fausto recorded the last phone call made by the debt collectors, which documents false claims that threatened the Faustos' livelihood. Credigy countersued the Faustos on the basis that the debt collection call was confidential. Humphrey said Credigy collection efforts did not end until a lawsuit was filed. Humphreys claimed that the jury award was the largest given to a consumer in a case brought under FDCPA. Manny Neuberger, an attorney for debt collector, fears that consumer lawyers may make the false assumption that all juries will award large damages because it was awarded in this case. The Faustos case is fact-specific. Neuberger stated, in the vast majority of cases, there is little or no evidence of actual damages presented by the consumer. That is one reason why. Huh?
That's because they don't deny, they don't make them produce the debt.
Right. That is one reason why other debt collection lawyers are not willing to let the verdict in this case affect their evaluation of other cases.
You watch how fast these, I bet you they never answer me.
Okay.
This isn't the first time I've done this.
Well, this is what we're doing with our conditional acceptances and what we're doing with our requests for
This is what you should be doing on these mortgage foreclosure cases.
Say that
again. You should be
again.
doing these letters on these mortgage so it doesn't get into default. Remember, it was in default at closing because they didn't transfer the documents till they did a prohibited transaction.
Right. So that's what the homeowners need to be going back after these banks and these lawyers for, committing a prohibited transaction.
They cannot foreclose on property that's not declared foreclosure property by a tax return.
And that's what we went over. I think that was back on 416.
Yeah, but do you know why they can't do that?
Well, we went through all of the code sections there that said why they can't do that. They have to transfer the note and the deed together into the trust and file a tax return before any property can become a foreclosure property.
Why do they have to file a tax return?
In order to claim and apply for the exemption of tax-exempt status.
Okay, that's number one. Why do they have to declare it foreclosure property before they can foreclose on the property by filing a tax return? What has that got to do with foreclosure?
Refresh everybody's memory.
Well, doesn't that tell you it's a tax issue? Now you need to ask yourself a question. Why is it a tax issue?
Because they got the gift. They got the donation. And they didn't pay the taxes on the donation.
They didn't pay the capital transfer tax.
Right, on the donation. It's not the tax on the donation, it's the tax on the transfer from the homeowner to the bank, right?
Right, it's a capital transfer tax.
From the homeowner to the bank. Not the other way around.
And when they do that's why they call it a forfeiture.
How can it be a forfeiture if they didn't pay the transfer tax of the donation into their pocket? How can that be a forfeiture?
Well, because they're making you pay the tax by forfeiting the property. Remember, you're the donor.
Okay, but the
So you have to order them to pay the tax, then you can deduct it from their estate.
Okay,
I have an actual case that says that.
What
IRS
is that case?
Hang on. Okay, everybody got this written up? The complaint is on the, I have the complaint too that they filed.
On this Fastos.
Yes, I have the actual
put the complaint down. Fastos.
You need to, you should never get into court on a debt case.
Well, they just keep coming after you and after you and after you.
They don't come after me.
Well, it's true. We have to learn to do our administrative process before anything gets to court. If you do your proper administrative process before you get to court, you'll never get to court.
Okay, tax cases. Okay, I think it was I'm trying to find the.
So that's the Diedrich case you're talking about.
I don't know if this is it, but it's an IRS case. And it says that the donor can order the donee to pay the tax.
We went over that already on the webinar at great length.
Yeah, well, that's the case. It says
Tom,
that.
okay.
But you have to do that. You can't just sit there on your duff waiting for these people to run over you.
Do you have the Diedrich case complaint?
That's not the case. Tax claims. I'll have to find the cases.
Well, I'm going to remind you here the donor case. Telling donee. You know which case it is in that case. What we're trying to get is some of these documents that people can use as examples to help fashion their issues.
See, unless donor fails to make payment of tax. If the donor doesn't make the tax, what does that say?
Liability for payment of federal gift tax is in first instance that of the donor, and donee is not liable unless donor fails to make a payment of the tax by March 15th following the close of calendar year. So is that this Schaefer's Estate versus CIR?
That's one of it.
So that's the Schaefer Estate case.
There's another one here that's even better.
Okay.
I think this is the case here.
88 TC Tax Court 769. April 1987. Well,
I had a whole thing on this. It goes into the
okay, but you'll know what it is.
yeah. When I see it, it's got a list of cases on it.
Okay.
It says that if the donor can make the donee pay the tax. If you order him to pay it, he has to pay it.
Okay. Okay, I'll just remind you this 88 Tax Court 769 case. Do we have any?
One of these.
Do we have any handouts this week, Gene?
Yeah, I'll send you that letter. The letter that I did there.
The Sears letter. The Sears letter.
Yeah, the Sears letter, yeah.
And that would take care of even mortgage companies, wouldn't it?
You can use this stuff on mortgage foreclosure. Everybody waits until it gets into court before they challenge it. What you do is you admit you owe the money by not challenging it at the when they send you a letter saying that you're in default.
Well, a lot of times when you send them letters and tell them that you're not in default, give them conditional acceptances, they just keep moving forward as if you didn't do nothing.
Well, then they're violating the Fair Debt Collection Practices Act.
Right. And what I've always done is go right into admissions and requests for production right at the very onset, whether you have a case open or not. Then when they don't answer, then you've got something when they haul you into court. Now you've got something to say, hey, we've got discovery that they haven't answered. And it's been 2 years and they still haven't answered it. So I'm going to ask this court to order them to answer it. Then that attorney and that company is going to know they're hung.
Yeah, they have to answer it.
I mean, how long does it take when you put out the letter that we went over last week informing the Criminal Investigation Department of IRS of all the violations of tax evasion? How long does it take to get an answer? You made the statement that they spit Elvick out in 2 hours. But they're not doing that now. Even these wardens and these judges that get these letters, they're not doing anything.
Getting what letters? You're generalizing.
No, the letter of the criminal investigation request into the IRS on all the tax evasions. The letter we went over last week.
Okay, who sent the letter in?
The defendant.
Yeah, what did they get?
They haven't gotten anything. No response. They haven't. Well, we got one guy that's in jail. They haven't spit him out yet. It's only been a week, though. So I wondered, people are asking, is there a time frame on this? You said they spit Elvick out in 2 hours.
Well, they were already out. He was already out. He was on parole.
On parole. What about someone that's in jail? It still is all the tax evasion that they're doing. It doesn't change.
Well, for something like, if you're in jail, you write a different letter than when you're out of jail.
Okay. But what we find that a lot of people over so many years have found that we're trying to find the recipe that will encourage these agents to do something and not respond to you with silence and keep on moving what they're doing as if you never did anything. And then they come into court and claim that you've already defaulted and on and on and on, and you've sent them 25 letters with no response, claiming all of these issues that we've been learning on these webinars. I'm sure that those individuals are trained to not answer anything. But I suppose if we came after them with this public law that you just had up there a minute ago, under the Fair Debt Collection Practices Act, maybe there would be some more teeth and stuff, and it might encourage these attorneys to back off.
That's what they're doing. They're going after people for money.
Yeah?
Trying to find that. I have a whole list of all these cases.
It takes time to find what you want. You just have to tell me what to make a note of so I can remind you. Which specific case it is.
It's a Commissioner of Internal Revenue case. It says that they have to pay the tax if you appoint them. That's why it's a tax issue.
Right. Okay. Well, I've got that down on my notes. So, guys, we're going to try and help Jean to remember these handouts tonight or tomorrow. And when I send out the webinars this week, we'll have some handouts, right, Jean?
Yes.
Okay. So I will just label, we've got 1, 2, 3, 4, 5, 6, 7 handouts here. And I'll remind you of that after the webinar. We're down to the final closing minutes. Have you got, what are you closing with?
We'll go over the, I'm going to go over a security agreement too.
Okay, go ahead.
I've got a UCC1 here.
You were supposed to give out a UCC1 example. People have been asking for it now for 3 weeks.
Yeah, this is it here.
Okay.
This is how you do a UCC1.
This looks very familiar to me. This is very, very, very close. I have to read word for word, but it's very, very close to what I've done and a lot of other people have done for a lot of years. I started out doing my first one in 98, and then I had somebody con me into canceling that, and then I redid another one in 2001. And I realized had I not canceled my 98 agreement, they would not have been able to take my house from me.
You need to do an ag lien if you
A
want
what?
to stop these for
An
ag lien.
Agricultural lien?
AG, agricultural lien.
Lien. Okay. Yeah, this is very, very familiar to me, what you're showing. What's an ag lien?
I'll show you.
Agricultural lien means an interest. Oh, you moved it away. I don't know where it went now.
There it is.
Where? Where?
It's right in front of you.
Agricultural lien, this is section 5, means an interest other than a security interest in farm products, which secures payment or performance of an obligation for goods, just a minute, my screen green went up, for goods or services furnished in connection with a debtor's farming operation, or rent on real property leased by a debtor in connection with its farming operation, which is created by statute in favor of a person that, in the ordinary course of its business, furnished goods or services to a debtor in connection with a debtor's farming operation, or leased property to a debtor in connection with the debtor's farming operation, and whose effectiveness does not depend on the person's possession of the personal property. That makes absolutely no sense. Explain.
What doesn't make any sense?
Well, first of all, I'm not a farmer. I'm not doing farmer business. How can I do an agricultural lien on a house that's not a farm? Come on, you got to come down to kindergarten level for me, Jean.
Do you know what farm means? I want to show you something.
Apparently I don't, because this is not making any sense to me.
I know. I'm going to show you something. You're going to get an education.
Oh my gosh. You got to bring this full circle, because I'm sure there's lots of listeners tonight that are going, what? It's not making any sense. Etymology dictionary. I'm sure I'm going to really get an education here.
You think you know what a farm is?
I have no clue right now. I'm telling you. And I'm sure you're going to show me that I don't know what a farm is. There's a farmer. A farm.
What does it say? It says
Farm.
now. What does it say a farm is?
Fixed payment, usually in exchange for taxes collected. Fixed rent. From FR, firm, rent, lease. From ML, firma, fixed payment. From firmare, to fix, settle, confirm, strengthen. From firmus, firm. Censub, tract of leased land, is first recorded early 14th century, 14C. That of cultivated land, leased or not, in 1520s. Phrase, buy the farm, die in battle. It is at least from World War II, perhaps a cynical reference to the draftee's dream of getting out of the war and going home, in many cases to a peaceful farmstead. But fetch the farm is prisoner slang from at least 1879 for get sent to the infirmary, with reference to the better diet and lighter duties there. Husband.
So it means fixed payment.
That's what you have in a mortgage. So
Yeah,
that's
that's
what
what
you do in agricultural lien.
Yeah, that's how you get payment.
Do you have a form or a format for that?
Yes, I do.
Can that be one of the, wouldn't that be the answer to almost everybody's situation?
What's your first clue?
It's a fixed payment. It's taxes. So we're all farmers.
What did they pass before they passed HJR 192?
14th Amendment? No, I'm way off on that one.
What law did they pass May 12th, 1930? You ever heard of Public Law 7310?
Yeah.
What is it?
That's the Trading with the Enemy Act?
No.
7310 is the, man, we studied that a long time ago.
Okay, you say you're not, why would you want to do an ag lane? Okay, what does it say cattle is?
Cattle, oh my goodness, is property. Cattle.
Where does it come from? What's that word right there?
Cattle, C-A-T-E-L, property. Capital, property stock. Capitalis, property chief. Caput.
No, principal. It says principal, not property.
Oh, that's right. Capitalis, principal, chief. From caput, head. See head.
You ever heard of a head count?
Yeah.
How do they value cattle?
By the number.
By how many what?
How many heads?
What does the Bureau of Census count?
How many bodies with a head on it? I don't know. You're right. It's a head count.
Okay, when you go through a toll booth, what does the word toll mean?
It's
head
like
count.
a head count. It's the same thing.
Yeah. When you go into jail, don't they do a head count?
Every night.
When you're in the military, your son's in the military, isn't he?
Yeah, they do a head count. You betcha. Formation in the
Okay.
morning.
So why are they doing the head count?
To determine the taxes? I don't know.
No, to determine the amount of capital they have.
Okay. So here you've got a sense development of fee, pecuniary, original, you bumped it off. Human capital is what we're all said to be. So that's why we do an agricultural lien, right?
Yeah.
So if we go back and do an agricultural lien, then the people that are squatting or holding the land or the property, the body or whatever, they're liable, right?
Yeah.
Okay. So let's bring that back to a foreclosure situation and possibly a court situation.
What does this say? Can you see my screen?
Title 5, Chapter 54, Human Capital Performance, United States Code.
Do you know who the head of the Human Capital Fund is?
The Agricultural Department, isn't it?
Yeah, IRS is.
Okay. Okay.
What does that say?
Where? The Internal Revenue Service collects the revenue that funds the Personal Management's Federal Human Capital Survey. Wow. Okay. So, would this be
Your money, and you wonder why they keep throwing people in jail? Your human capital.
Yeah. They get paid for every head in the jail.
Right.
Okay.
The IRS works for the Department of Agriculture.
So if you do a lien, agricultural lien, what does that do? Explain that.
Gives you a lien interest. What did you just read from 9-102? I bet you didn't even remember what you read.
No, I have to go study it harder. I don't have it off the top of my head like you do.
Okay, it says you have the right to execution and payment on the contract.
Well, that's the possessory right and the proceeds. Right?
Yeah.
Okay.
Here's the case you were talking about.
Okay. 1-05-1829.
It quotes the Henwood case.
Okay, U.S. Bank is trustee for New Century Home Equity Loan Trust versus Anthony B. Phillips, defendant appellant. Okay. Okay.
But you're entitled to, when you put a lien, that's why I took you in there to, and you forgot it already. You need to write this stuff down.
Well, we do write it, and we are studying every week.
So your human capital, do you ever get reimbursed for supplying capital?
No, we don't get jack squat. We need to get reimbursed.
Why do you think that is?
Because we're doing all the labor.
What does this say?
Where?
Agricultural lien. I want you to read that.
Agricultural lien means an interest other than a security interest in farm products.
Yes?
So explain that.
Well, you left out the most important part. Which what?
Which secures payments or performance.
Which does what?
Secures payment.
Which does what?
Secures payment or performance of an obligation.
Okay, what's the obligation?
So how do we secure payment?
By filing an ag lien.
Okay, so we're telling them that they have to be responsible because they are going to secure the payment or the performance on our behalf as a beneficiary?
Yeah, they have to, you get paid. This is how you get paid.
Okay.
You're the one that's putting up the human capital.
Okay. So do you have a format that one of these lien examples we can look at?
Yes. We're not going to have time to do it tonight, though.
Can you just show it tonight and we'll bring it back next week?
I'd have to,
I've got it down on my list, the agricultural lien format.
I want to show you something.
Powers and duties of Federal Reserve banks. Title 12, Chapter 3, Subchapter 9.
Read this from here down.
Provided that notes, drafts, and bills of exchange with maturities in excess of 6 months shall not be eligible as a basis for the issuance of Federal Reserve notes unless secured by warehouse receipts or other negotiable documents conveying or securing title to readily marketable staple agricultural products or by chattel mortgage upon livestock which is being fattened for market.
So you're cattle or livestock. So they're using you to underwrite as collateral to print Federal Reserve notes.
Right, because we're being fattened for market.
Right.
Okay, folks, we will look for an example of an agricultural lien in the handouts, and I'll be in contact with Jean tonight and tomorrow, and we'll get these handouts going out, and they should be with the webinar recordings this week. Well, with that, Jean, we've gone almost 20 minutes over our time, so again, we want to say thank you to everybody. We did not get to all the questions. We're trying to get to them as best as we can and not jump around too much with the questions. But this might be one of the key areas that we can do to preserve our rights to the possessory rights and to the proceeds of our mortgages and court cases, that we have a right to claim on such agricultural lien. With that, Jean, closing words?
I love you all. I'll see you next week. Read your book, Zero Limits. I'm going to give you a test next week.
Thank you very much, and we'll see you all next week. I'm going to stop the recording now. Thank you, and good night.